Let's get going. I want to welcome you all to the House Higher Education Committee meeting. We're here today to hear House Bill 37. The committee will find that in their notebook. Just a few comments before we get going. It's just for the committee especially. We had a big meeting on Monday, and I heard from a couple of y'all would like for me to schedule some smaller groups with the speakers who were there to really do a little bit deeper digging into some of the issues and some of the different agencies that we heard on Monday. And I'll be working on that, try to find a time under the new schedule to just schedule those. It's probably early in the morning just to get y'all's knowledge up, and mine too, of some of the different agencies that this committee works in. And I think it'll help us all. And for the great group out there, look around. You ought to be sitting here looking at y'all. I'll take a picture of you in just a minute. We'll have a big selfie. But in a big meeting like this, I just want to just bring out two things. One is respect. You'll find in the House of Representatives and the Senate and in the General Assembly, the respect for other people's opinions is very important, and we'll do so here. We'll listen to one another, and then the committee will work and do what they feel is appropriate. So that means no booing or yaying or saying and all that kind of stuff. We won't tolerate that. So South just appreciate it. So without further ado, we got 1 hour. I'd like to ask Chairman Earhart if he will take the seat over there. Or you can sit right there, Chairman, whichever you would like.
You're okay. I'll sit right here.
You're just right there. He is a member of this committee, and so if you're looking at LC 288184, for those of you in the audience, this is not a substitute. This is the original bill that was filed. Chairman Earhart.
Thank you very much. Chairman Bass, members of the committee. And,
Oh, excuse me. Which number are you? I'm sorry.
36. Oh, we're number 2.
2. I'm sorry. There you go.
The light's on, so we're good. Thank you, Mr. Chairman, members of the committee, members of the public that are here. House Bill 37 is a very direct proposition. There's not a lot here, as you can see. It's a page and a half of bill. This is, for lack of a better term, a piece of legislation that effectively restates the sanctuary city statutory enactment that we have here in the state of Georgia. That's actually what I asked the Legislative Council to do, was to track the current state statutory provisions with respect to sanctuary cities and state funding. We had some conversation over the last 4 or 5 months with respect to certain campuses giving certain signals with respect to whether or not they wanted to be a sanctuary campus, and effectively disregard and not enable not communicating with federal authorities, not cooperating with federal or authorities with respect to the actual laws. Now, nothing in this piece of legislation, I'll state categorically, says you can't advocate for that. I would never come between that. But we have a system of laws in this country. There may be a lot of laws that I disagree with. I think maybe that's a basic tenet of being a legislator. But every one of us in this room has come to be an elected official, and we're working inside of the process. There's a way to change what the laws in this country are, and it's through reasonable debate, and it's through gaining enough votes to change the rules. But to unilaterally, if you're a university or an agent of the state, to say that we're going to pick and choose which laws we follow, I think that's a very, very bad idea. And so that's what this says. It says that if you choose not to follow the laws of this state or the federal government, then this state, through its tax dollars, is not going to choose to follow you. You can do that if you're a private institution. Now, the Regents have made it very clear they will follow laws. And, again, frankly, the universities that were having this conversation have made it clear to me that they are going to follow the laws. But it's always a good idea to have an underlying statutory authority with respect to this. And you'll see that it says that if you do not follow the law, whether it's this law or any other, you're not going to gain state funding, i.e. scholarships, grants, research, or state tax dollars. Mr. Chairman, that's what this piece of legislation does. I'm open for questions.
Thank you, Chairman Earhart. Just a question I have off the top. Have you been contacted or approached by any of our private, as it's listed here, schools that they're not?
Actually, I've
follow this
been,
law?
to the contrary, I've actually been approached by the original school, Emory University, has come to me through their agency and had said very clearly that they are going to follow the law. And I believe they sent that out to their student body and to their trustees and everyone else. I've worked collaboratively with Dr. Baxter and the independent private institutions, and she assures me and they assure me that they're going to follow the law. I try to keep it as simple as possible.
Yeah, I think you have. Committee members, if you'd punch in, if you have a question, just punch your number. Number 3. Sir, Mr. Representative.
Thank you. Chairman Earhart, if all the private colleges, universities are currently following the law, and they said they are going to follow the law, is it worth it going through this process, and potentially if it's going to make folks that are doing their best to follow the rules uncomfortable on some of these campuses?
I think it is worth it, Representative. I think rather than have a less than clear statement of what the law is, it's always better to have a clear statement of what the parameters are. And as for an uncomfortableness on some of these campuses, I remember looking forward to being uncomfortable on a college campus. That's the place to have competing ideas. It's the place to be made uncomfortable with your basic premises. So I think, unfortunately, and I don't think I'm not suggesting you're advocating this, but I think on some of our college campuses, dissent is seen as a excuse to curl up in a ball and not engage. And I want that portion of our youth to engage. My toughest instructors were those who disagreed with me the most, but I respect them more today than any of the others.
I'm trying to think of a situation. My grandfather was an undocumented immigrant, and rose and managed a large factory and did great work, and I believe he was an asset to this country. And I certainly respect that unpopular theories do need to be debated, and people do need to feel uncomfortable sometimes. I'm just worried about that 18 and 19-year-old student, a DACA student, who is not worried so much about being discriminated against for ideas, but for who that person is. And that's the person that concerns me, and I want to feel that person privately paying for their education can get an education and then contribute to Georgia.
Fair question, Representative. As you know, this doesn't go to the statutory underpinnings of DACA or DAPA. That will be a federal legislative enactment or executive order or however it comes down one way or the other. This is tailored specifically to the concept that you must follow the law, whether you're a DACA student or a student who's lived in the state of Georgia all your life. I think you've even heard this administration make some very serious statements with respect to let's have a conversation about the Deferred Action Program. That wasn't in one of the very first executive orders. So I don't think this legislation goes to DACA, but this legislation is specific to the clear understanding that let's turn it around. Let's say there's students on campus whose philosophical orientation says we do not like the enactments of the Environmental Protection Agency. Therefore, we and our trustees want to go out and say we're not going to follow the EPA because. Give you an example. Let's say that the EPA, my educational efficacy is going to be affected by whether or not we can build a building on campus that's going to house my academic specialty. And if that building's not built, I'm not going to get the education that I was going to get. But the EPA says there's a stream, and that's the only place on campus. So can I, as a university administration, unilaterally not pay attention to that law, or can I work to try to change it? I think there's a true corollary between these things. We've got to have a basic respect for the underlying laws. We can debate, and I think we have a serious debate on the deferred action program for those kids. And I think reasonable people can have a very poignant discussion on that. But I want to make sure that the laws in Georgia are clear with respect to state taxpayer funds won't follow those who don't follow the law, whether it's DAPA or whether it's EPA or whether it's an Interior Department or something.
Last question?
Sorry.
Yes, sir, please.
I guess with that example, though, anybody that flouts the EPA regulations is going to be fined and probably stopped from building that building. So there's already a mechanism in place for violations of federal law, though, right?
Certainly, there's mechanisms in place for violations of immigration law currently. Right now, currently there is no penalty under the existing executive order with respect to the deferred action program. So they're where they are legally until and unless the federal laws change. Same would be with respect to an EPA. I mean, it could change.
Is it good?
Thanks for your questions.
Any other committee members have a question for the bill sponsor? Very good. We'll go on to public comment before we move. First we have on this is Susanna Baxter. If you will, when you get up there, just tell us, who you are, who you're with. We'd appreciate it.
Thank you. Good afternoon. I'm Susanna Baxter, president of the Georgia Independent College Association. I have the honor of representing 25 of the not-for-profit private colleges in the state. I have conferred with our member college presidents, and we are in agreement that we do follow current federal law and will continue to follow federal current law. Therefore, we have no problem with the current provisions of this bill.
Here, even committee members have a question. Representative Gar, you're just blinking? Okay.
I am just blinking. I'm not sure why.
Okay.
Thank you.
There you go. Yes, sir. Hang on. Are you on? Or
Yes. Thank
There
you,
you
Mr.
go.
Chairman. So that if this is clearly understood from the independent, nonprofit colleges and universities, you're saying that you have no problem in supporting this bill?
The current provisions of this bill, we follow federal law.
I understand
so
that.
we have no trouble with the provisions of this bill.
So, under this bill, you have nothing in this bill that you could not support.
Correct.
I just wanted to clarify that.
thank you, Representative Chairman Battles. Any other committee members? Thank you, ma'am.
Thank you.
Next was Thomas Weaver. Oops, sorry. Thank you.
Chairman Jaspers, members of the House Higher Education Committee. For those of you who may not know me in sessions past, I'm Thomas Weaver. I'm a private citizen, and I advocate under my First Amendment constitutional rights to petition the government for addressing grievances. Here we are, we find ourselves in the era of fake news, and somewhere in between half-truths and whole lies, we find ourselves somewhere in the middle. Originally, I believe that this legislative proposal was crafted in response to Emory University's the news media blowing up. There's going to be some sort of sanctuary policy there. And then in an op-ed released by the Atlanta Journal-Constitution today through their investigative journalist, their tentative president, Ms. Claire Stirk, who's actually scheduled to take the reins of their university here in one calendar week, has actually gone on and backpedaled on that, saying, actually, no, there's going to be no sanctuary policy here. And to me, it's much brouhaha about nothing. But having shared that, looking at it from a public policy standpoint, I can certainly learn to better appreciate the merit of House Bill 37. The Georgia General Assembly has, in years past, advanced a very strong public policy position in regards to this particular subject matter. And if it would be within the desire or merit of this committee to advance the due passage favorable recommendation on House Bill 37 in its current form, to further enhance that public policy stance for potential engrossment and enrollment before the full House on the floor under the the leadership and shepherding through the majority leaders, then that certainly would be consistent with advancing that goal. Having shared that, I looked at it through the lens of encroaching on private property, because I know that we here in Georgia hold very near and dear to our hearts the fundamental concept of private property ownership, and a man who owns private property should be able to do with or not do with their property as they please. But in this bill, it doesn't touch on that, because it's not infringing or encroaching on Emory's University to do or not do as they please, but rather it's solely the state taking a public policy position that should any private educational institution in this state refuse to comply with statutory law, then the state would withhold state grant monies, which the state is vested through federal law and through governing state law to allocate or refuse to allocate based upon that occurrence. So for me, if this legislative proposal should go through to the floor, then by all means advance it. But it seems to me that Emory's president saying that we're not going to do it, which is what you heard from the former speaker in their testimony. So it's really up to this committee. But with that, I'll conclude my statements, and thank you for allowing me to speak, Mr. Chairman.
Thank you, Mr. Weaver. Next up, I'm going to do my best. Aisha Yaqub. If you just tell us who you're with, and we sure appreciate you being here to speak.
Thank you, Mr. Chairman. Like I said, my name is Aisha Yaqub, and I'm here with Asian Americans Advancing Justice Atlanta. I'm here today to urge committee members to not support HB 37, a bill that has many flaws. The bill's intention is to punish sanctuary campuses or institutions that support sanctuary policies. These sanctuary policies are broad in spectrum and may not be defined as such in university language. Universities may choose to adopt a wide range of policies that protect students of all kinds, not just undocumented students. In addition, the bill's language focuses on policy preventing university officials from communicating with law enforcement in regards to a student's immigration status. The Family Educational Rights and Privacy Act, or FERPA, which almost all colleges and universities adheres to, prohibits the university from disclosing student information without his or her consent. Any policies forcing employees to disclose immigration status of students would be in direct violation of FERPA. Additionally, this bill would allow the state to withhold federal funding for private institutions. Federal law states that states cannot withhold federal funding if the institution has not broken any federal laws. There is no federal law on the books about sanctuary campuses. Similarly, an internal memo from 2011 from ICE designated college campuses as sensitive locations or no-go zones. Sanctuary policies are designed to codify and reiterate that ICE officials are not in fact allowed on campuses. Attaining higher education is an issue important to all. For many undocumented students, the prospect of college is tough enough. Being able to learn on a safe and welcoming campus can have a significant impact on a student's mental health and well-being. Public colleges and universities in the state are already bound by the policies promulgated by the University System of Georgia's Board of Regents. Private colleges and universities in the state should have the ability to dictate their own policy as long as they are operating within the bounds of the law. In the state of Georgia, private colleges and universities are often the only ones available for undocumented students. Policy 4.1.6 of the Board of Regents bans undocumented students from applying to the state's most selective schools. Policy 4.3.4 requires undocumented students to pay out-of-state tuition at every public school, which is over 3 times the cost of in-state tuition. Private schools should be able to provide an alternative to students seeking an education. Thank you.
Hang on. Either of the committee members have a question for our speaker or comment? Thank you, Ms. Aisha. Appreciate your comments. And across that, and Ray, tell me how you say Serrano?
Yeah.
Is that right?
Yeah.
Good. All right. Come on up. And while he's coming up, I do want to mention that committee, I didn't say it at the very beginning, but this bill will be available to move if the committee desires it at the end of the comment.
Hey.
Yes, sir, Mr. Ray.
Hey, good afternoon. My name is Ray Serrano, and I'm a graduate student at Emory University. For the past 4 years, I've been working with another group of graduate students, for Black and Latino grad students, on recruitment and kind of admissions policies at Emory. So we've been trying to we've gone to Agnes Scott, we've gone to Dalton State, we've gone all over the state, trying to get people motivated to apply to Emory, to come to Emory, and to communicate some of the resources that that are available for high school students and at the graduate level for undergrads. That being said, we are obviously very passionate about tapping into Georgia's talent, people throughout the state. At Emory, we hope to attract. We've been focusing our efforts on underrepresented minority students, particularly first-generation college. And one of the things that we found a lot with this is that underrepresented minority students and first-generation college students often, going away from home is a big factor. So why recruit in California when we have talent here in Georgia? So we've been doing that with the kind of Complete College Georgia initiative from Governor Deal. So I have to. One of the things I want to just mention about one of the questions that we constantly get, I get a lot of the other students get, is if we come to Emory, what will it be like? Will we be welcomed there? Will we be discriminated against there? One of the and this question particularly comes from a lot of undocumented students throughout the state. They ask us very frankly, what is it like there? What is it like for you? I'm a first-generation college student. My dad was undocumented, and I speak very profoundly and very positively about Emory. I speak about Emory as I say it's a great university. It's an awesome place. I mean, I've gone to school there for the past 4 years. I'm living in libraries, but it's a great place. And I say that my worry about this bill, HB 37, is that it limits the ability of administrators to speak about how great a place it is. We will not be able to, the idea when a lot of us signed the petition, the November 20th petition that went out. And the reason why we signed the petition, it was not to basically declare Emory a rebel university. We didn't want Emory to be a bad university. We didn't want to say Emory's defying the law. We're just saying if you're going to come onto our campus, do it right. Get a judicial warrant. That's what we're asking for. This bill goes a step further and says that Emory somehow is trying to skirt the law, and now we are trying to somehow defy the law. My concern about this is that HB 37 would virtually strip administrators of their ability to ensure that their university is a welcoming place. It has unnecessarily punished universities for making statements that would declare their campuses a safe place to live and to learn, and I urge everybody to not support this bill.
Thank you. Committee members? Okay. Representative Garner, go ahead.
I'm Sri. Thank you,
Gotcha.
Mr. Chairman. It's my understanding from reading the Emory Wheel that Emory will not declare itself a sanctuary campus, but they maintain the current procedures, policies they have to protect every student to the best of their ability. Is that true?
Yes, I mean, so the idea that they're not using maybe the phrase sanctuary campus, but the idea is that they're trying to protect the students that are there. From our standpoint is the students that are not there now. So when we go around Georgia and we're talking about the great opportunities that are available at Emory, the question there is, what is the message going to be like for those generations? Is the university going to stand with them? Is it a safe place to live and to learn for those students, future students?
May I ask additional questions?
Yes, ma'am, please.
So what beyond your status, what other kinds of things can the federal authorities come into your campus and seek from you? You know, beyond
This is beyond my pay grade. So.
well, maybe I'll ask a lawyer. Maybe I can ask. I'm sorry I was late, Mr. Chairman and Mr. Sponsor. Yeah.
But
I don't understand the breadth of this bill.
I mean, I think there are procedures that the university already has in place that when somebody from law enforcement wants to come on a campus, they would contact Emory Police, they would contact the Office of Campus Life, then they would come on to campus. But usually they require certain things to come on.
So obey the law, but have procedures.
Yeah, like any other institution, any private institution would have that, right?
Thank you.
Yeah.
Okay, Rick, can you go to, is that 4? This is Ms. Representative Bentley.
Thank you, Mr. Chairman. I've just been hearing a lot of talk about Emory, and I know there was a representative that spoke on behalf of the private institutions, but are we going to hear from institutions like Morehouse or Clark Atlanta I'm just curious to know what some of these other institutions, will some other individuals from representing those institutions be here to speak today?
We will, if you could have, Ms. Baxter, would you please comment on that? You might not have heard her.
Yes, I represent 25 of the not-for-profit private colleges. Morehouse and Clark Atlanta are among them. And our presidents, we currently follow federal law and have every intention of continuing to follow federal law. Therefore, HB 37, the provisions that are in this bill are of not concern right now because we follow law.
Mr. Ray, thank you for being an advocate for Emory.
Thank you. Yeah.
Good job. Next is Ashley, you'll have to tell me, Rivas
Triana.
Triana.
Yes.
Next, thank you.
Thank you for having me. Hello, everybody. Hello, committee members. So first and foremost, I come forward to this committee as a student. I'd like to make that clear. I am currently an undergraduate at Emory University as well. That's where I'm doing my studies, and I'd like to point out that it's a school that prides itself on its legacy of providing students with a world-class education, preparing global citizens that are invested in courageous inquiry. But I believe that the single most important factor that contributes to that world-class exemplary education is its commitment to diversity and protecting our students. So, that being said, I also come forward to this committee as an undocumented student. One that I've lived here all my life, and I do in fact follow laws living here. So I was also one of those students that came forward to the administration proposing the petition to declare ourselves a sanctuary campus. We did this right after the election of Donald Trump back in November. So, in urging Emory to become a sanctuary campus, we never once encouraged or demanded that Emory break the law or skirt the laws in any certain sort of way. What we really were trying to demand from the school was a strong stance on the commitment to protect not only the students that are currently there, like myself and many others, but any future students that may feel scared, vulnerable, and questioning their future, their educational future. So, that being said, I would like to encourage this committee to definitely consider not passing this bill because bills like this did in fact create that uncomfortable situation that Mr. Earnhardt mentioned. And while I agree with him that we do go to college to be uncomfortable, to have our views questioned, I don't think we go there to feel uncomfortable about our identity, about who we are, to feel scared about going to school every day. And I think that we need to reinforce the fact that Emory is a place of education. It's a place where we go to create global citizens, and it's not a place that has any intention of participating in deportations or in making their students scared of going there every single day.
Committee have any questions for her? None? Thank you very much, ma'am. Okay, any other committee members have any questions for the bill sponsor before we, right here?
Thank you, Mr.
Representative
Chairman.
Casas.
Representative Earhart, Chairman Earhart, I'm always for any provision that will strengthen the law, but help me understand. Is there a scenario where an independent university or college could adopt a sanctuary policy where the city that they're found in does not ascribe to sanctuary policies, or a state prohibits such policies? Like, can a school go rogue?
Excuse me, Mr. If I understand your question, could a private institution create a campus policy that, in effect, enabled non-cooperation with a federal warrant, let's say, arrest warrant, something like that?
Right.
Nothing would prevent them from passing such a policy, other than the existing laws in the state or in which they resided, or the federal laws in this nation in which they reside. The downside risk for the university would be, in the case of a federal warrant, possible judicial proceedings with respect to that university. If someone wanted to bring suit, if a U.S. attorney in that sense decided that that was the case, they could do that. I mean, in this country, you have the capacity to bring a legal proceeding for just about anything, and that's not necessarily a bad thing. With respect to policies for the state of Georgia, what this, as Dr. Baxter said, these institutions are going to follow the federal laws. So what this statute does, what the statutory provisions we have in our current statute with respect to sanctuary cities do, is it says if you choose to, this is a consequence, if you choose not to follow the law, here's the consequence.
Okay.
Lack of funding. So just as with most statutory provisions, that's the reason we have them, with a view towards deterrence of that particular behavior, whether it's behavior that says that, or laws that say you can't speed through a neighborhood, or whether it says you can't not follow the laws of this country. There's always a consequence to not following the law.
Any other members of the committee have questions? Ooh, any other members have questions? 6. Representative Holcomb.
Thank you, Mr. Chairman. Chairman Earhart, I want to make sure that I understand the background and the context, and then what the bill does. My understanding is that after the election, Emory and perhaps others indicated that they would declare themselves a sanctuary campus and not comply with federal law in some measure?
There was that intimation. I don't have a list of the student demands that were made. I believe there's one other institution, Agnes Scott, made certain representations to that effect. Now, as you've heard in testimony, Emory's made it very clear that they are going to follow the law. Dr. Baxter said that all the institutions are going to follow the law, and I think that's great. I just want to make sure that there is a law, that there is a consequence with, if at some further point that, I mean, we do have sanctuary cities in this country. I mean, it's not unreasonable to assume that individual institutions or cities would go down that road. I'm not saying that you can't make an argument, but I'm just saying that that's not unreasonable to assume that somebody could do that. And what I'm saying is that I think that the public policy of the state of Georgia should be that if there are institutions that choose not to, not that they can't advocate for, but if they choose not to, the downside risk is that the state funds won't flow.
And what are the specific actions that the sanctuary declaration would protect?
Generally, it follows in the form of not responding to federal agency requests for detainers or for warrants for criminal activity or for other information and that type of thing from under the federal statutes.
Understood. Do we have any examples of that happening?
Not yet in the state of Georgia, no. We don't have any, but you can look at the sanctuary policies of cities in other areas of the country, for examples of, I think Travis County in Austin, Texas is an example of the difference of opinion that sheriff is having with the governor of the state of Texas, saying that they are not going to respond to detainer warrants and those types of things. Just as a campus, as an example, if a campus police agency beholding to the, say, Emory University or any other university, was told by that university that the policy of this institution is we won't respond to those, then that university police agency is in a really difficult spot. Those individuals have taken an oath to follow all law, state and federal, but yet their job and their work is through the university itself. So that creates a really difficult tension for those law enforcement officers, notwithstanding that it would be a violation of federal law.
Okay. So there's no examples of this happening prior, and I think all the testimony that we've heard is that everybody's going to follow the law going forward?
That's correct.
Okay. So is this designed to prevent any schools from declaring themselves as sanctuary institutions? Is that
Depending
the end
on,
game?
well, no, depending on the definition of sanctuary. I mean, you can, word definitions, if sanctuary means to one of these institutions that we're going to support individuals that are here currently through the DACA program and that kind of thing. And that means through counseling services, it means through programs for them and things that are legal under the law, then there's no issue. It only becomes an issue if it is a clear violation of a statutory authority or a regulatory authority in the sense of the current, it's actually an executive order authority, which is clearly legal and constitutional with respect to the current deferred action program that the former president signed. So right now, that's the law in this country.
Okay. And is it that this legislation would only be triggered if a university actually adopts a sanctuary policy? So it's university-wide, not individual activity, or is it?
Well, yeah, it's university-wide. I mean,
Okay.
if we tried to craft it so the languages that the university does. Now, if an individual on a university campus breaks the law, that's a separate judicial remedy.
Okay. And I'm almost done, and thank
No,
you
it's fine.
for letting me
Your
walk
questions
through
are
it.
always thoughtful.
Thank you. We're good friends. In terms of violation, the violation results in withholding of monies, and that's the stick, right?
That's correct.
How is that violation determined? Is it just by the declaration that they are a sanctuary university, or are there some other criteria?
No, I think but before you would place yourself in, I mean, if you're the state, let's just say it was with respect to state funds. I think that the state would want to have a clear fact basis for saying that this university is violating this specific statute. Let's say it's a detainer warrant. That's a fairly specific thing that happens in some of the sanctuary cities. Without a set of fact base, the university would have a basic cause of action against the state if you withheld those funds. So the state would have the burden of proof that a state has the capacity to act previous on these types of things. But I'd submit that the state would not act if they didn't have a fact base for that.
Okay.
Because then they'd lose. They'd get a summary judgment probably if they just said, we think you're advocating for this and we want to withdraw state funds. I doubt we'd have we wouldn't have a leg to stand on as a state.
I don't see a burden of proof in here, so what would that be?
Now, that'd be under the same burden of proof that any state action that in any way, shape, or form curtails any private entity or any, depending on what it is. If here the burden of proof would be in, I suspect, let's take the example. I suspect that if Georgia withheld funds because there was a prima facie case in the mind of the state of Georgia and the let's say the scholarship funding, that there were 15 detainer warrants for those who federal authorities, and they had what the state considered evidence to that effect, and they utilize that, and the state would probably get an opinion from the Attorney General's office with respect to whether or not that evidence was sufficient to move forward. If the university or the institution thought that was without merit, they would immediately go to the courts. I suspect they'd go to Superior Court in their jurisdiction and make a case, and it would flow from there. Now, I may have missed a step or two in there. I mean, you're a good lawyer. There's a lot of ways that could play out.
Right. Okay, thank you. I appreciate that. That's it. Thank you, Mr. Chairman. Chairman Earhart, though, if in that scenario, if the university has to go to court, they would bear the burden of proof because they're bringing an action to try to get their funding back, and haven't even done a declaratory judgment action. Those things can take 12 months, 18 months, 24 months, and it would impact every student at that campus.
Believe me, I'm very aware of the difficulty of suing your own government for relief. If you've ever dealt with a federal agency and wanted relief from an EPA regulation or anything else, I would like, believe me, I would like a very speedy trial.
Right.
But I'm not being flippant with you at all. I'm just saying. I mean, we have federal agencies that have made a practice of placing federal funds at risk for all kinds of strings, from Medicaid to. I mean, we've all dealt with the federal government on a state level that says, okay, here's what you got to do, and we'll take your funds if you don't. That's pretty settled procedure and process. Whether it's burdensome, you and I are on the same page with that.
I'm just wondering though, because I agree. If you're in a situation where you've got to do a mandamus or some kind of other action to prove the state is acting incorrectly, is there a way that we could that this could be stayed until there is a court allowed to determine that? Because I'm thinking of a large university, and I'm thinking of all the students, and a lot of students would have no part of this at all because they're just scared to get an education, and a lot of students would probably want it to be a sanctuary campus, but it doesn't matter.
Let me give you an
every single
example.
student can be affected.
Let's take a recent relevant example. I mean, you can go to court and get a stay fairly quickly if you think you have the right fact pattern to get it. We just had a federal judge in Brooklyn, New York, have a difference of opinion with the new administration with respect to the recent immigration executive order. They got an immediate stay, and things were not only moved along with certain provisions of that. I mean, it's especially again, it depends on the offense. It depends on the pattern of facts. I mean, if it's crystal clear, again, back to that detainer warrant. You know, if you got a federal marshal comes in and testifies that the campus absolutely would not take this warrant for this armed robber, and you can go into the Superior Court in that county and say, here it is, here's the testimony. I'd say the Superior Court judge wouldn't look too favorably upon the institution. But if in the corollary, if the state just said, because we want to, because we think the university is claiming that, then I think they'd get a stay pretty quickly. I mean, I have a lot of confidence in at least in our Georgia courts. They generally act reasonably. I mean, I haven't agreed with everything, but more often than not, I do.
Just to protect those students though, who obviously are on a timeline and need to get employed when they get through the university in 4 years, would it make the bill a little clearer if we could put the burden of proof and maybe some kind of stay language in there while it goes through the court?
That'd be a fairly radical departure from the basic burden of proof in any judicial proceeding. I don't know that I'd want to go down that road unless we're going to do it for every single agency, individual, everything. I'd like to have that as an individual. If I disagreed with a regulatory or a statutory state enactment, and as a business owner, I wanted that burden of proof to be shifted. I don't know that we want to go down that road if we're going to swap the burden of proof.
No further questions. Thank you.
Any other committee members?
I think Representative Gardner has another question.
Got a lot of emails about this.
That's fine.
I'm sorry, I can't. If you'd represent, if you'd approach and just tell us who you are and at the end right here. Yes, ma'am.
Who's asking a question? Pat or?
Oh, Pat.
Sean.
I didn't see you, Pat.
That's fine. Go ahead.
Thank you.
Thank you, and I apologize for interrupting. State Representative, District 99, Brenda Lopez. I'm actually an immigration attorney. This is the practice area that I have expertise in. And I just wanted to clarify and also just two follow-up questions to that. In regards to particularly ICE on the enforcement side and their procedures, when and if, and this is a clarification between what people could term as sanctuary cities and sanctuary campuses. In regards to cities outside our state, because we don't have such a thing here in the state, that is the police department and law enforcement generally deciding whether or not they want to comply with certain detainers by ICE. But this is law enforcement to law enforcement. And that's I think, I believe, key difference for us to understand within this committee, that sanctuary campuses is not an outright, as was mentioned before by everyone else here, is not a departure from not complying with detainers, because they are not law enforcement. That's one point to clarify, that those are two separate things. The other thing is that ICE has, well, I cannot say never, but I know of no time ever where ICE as an enforcement side has ever gone into any sort of college or university, or for that matter, public education system, PK through 12, precisely because as was mentioned before, that's exclusively taken off, because as we can understand here, we may not want to start detaining people if that may be the need on any sort of education campus. However, if ICE had a detainer on any person that happened to be a student at any university, or for that matter in any PK through 12 school, if they had a detainer and they had to have a state assistance, that would be through any sort of law enforcement, whether it be at the city, county, or state level. That would not be a request that'd be coming down through any college or university. So just to keep in mind again of what we're really talking about here. And the second thing to that is that even if we accepted that we're just going to state in law a fact that universities do in fact comply and will in fact continue complying with federal law, which they do and have been doing, and will continue to do so, then the other question that I would have, even if we wanted to take that as for argument's sake, would basically taking away funding be maybe the smartest approach? Because it's true, sometimes we do need penalties for certain violations in cases, as you mentioned yourself, rogue institution, and hardly do we think at a university level someone's just going to go rogue that extreme where they would actually not comply with any type of federal or state law for that matter on purpose as a university-wide policy. So, but even if we assume that there's the circumstance could exist, because any circumstance could exist, right? Any hypothetical could exist. Even if that were the case, would actually taking away state funding be the only prohibition or penalty that we could have? Could there be some other? Could there even be levels of penalties that don't go to the extreme of removing funding, which goes back to what Representative Dreyer and Representative Holcomb were discussing about how difficult that would be for an institution, not only for a large institution, but actually to a certain extent even more so for a smaller institution that may more heavily rely. Maybe I would say Emory could hold off a little bit while they figure out the legal proceedings, but a smaller university I think would heavily be affected by having to go through any legal procedure, and would their funding and the percentage that the state funding could amount to could sever it between being a functioning school and a non-functioning school, and what that repercussions mean for our state, that we would end up closing colleges or universities while we figured out the legal procedures. So is that a possibility?
Is it not true, Representative? That's a very long question. I mean, I think you've.
The first was a clarification, and the second part
clearly made your point of view, and that is our role down here. And Mr. Chairman, there's a list of questions. I could spend the next 35, 40 minutes. Most of this, I'd say everything that the representative addressed, I addressed in the original statement to the committee. If there's a specific question that has a specific answer.
Is there another possibility in terms of penalty, if you want to have a penalty that does not include removing state funding immediately?
Representative's always a different way to do something. I'm fairly happy with this proposition, and I've had a bill drafted, and I've asked this committee to agree with this proposition. Again, if there's a way to do it differently that you feel strongly about, then draft a piece of legislation and bring it to the committee, and I'm sure they'll give you a very respectful hearing. I would.
Thank you, Vice Chair. Thank you.
Thank you, Representative. Representative Gardner.
Thank you, Mr. Chairman. Representative Earhart, I understand the message. Actions have consequences. And I understand that strong message. There's also another really strong message that is striking fear into all these students for a whole variety of reasons, because they're probably not lawyers like I'm not a lawyer. And who does this apply to in addition to the detainers, which are covered clearly by federal law? So that's one question. And you, I think, started to answer that. The second question, well, why don't you answer the first question first?
The law applies to institutions in the state of Georgia, private institutions that would choose to not follow federal or state laws. It's just that simple.
There are a raft of federal laws, and this allows the police authorities to go into universities, perhaps not with other law enforcement.
No, it just says that if you don't follow the existing federal laws, it doesn't create any new cause of action for federal authorities or state authorities to go onto a campus. It just says.
How do you know they have not followed federal law?
Again, there could be a lot of examples. There's a lot of federal laws, especially in this arena. If that would be a fact pattern, you would have to establish it. How do you know that somebody hasn't followed the law if they're prosecuted for any number of transgressions? In this country, we have that capacity to make our case either way, and the universities would have that ability. But they've said they're going to follow the law, so then it's a moot issue.
Well, I just think there is some understanding that it applies more broadly than it's intended.
I can't be responsible, Representative, for people's misunderstandings and their fears, and I really want to encourage our university students to, the real world is a fearsome place, and they're going to have to join that once they get off of the safe campuses, and we're making campuses so much into a padded room that you can't have any dissenting opinions, or you're entitled to some not being insulted or not having to defend your opinion, that it becomes almost a tort on campuses. So no, I'm not going to spend a lot of angst on that.
I understand that we disagree on probably the role and what's happening in our current university, but if federal law exists, it's confusing to me why we need a state law to enforce and ensure that federal law is followed.
We have a state law on sanctuary cities. This is tracking the current state law.
Thank you. I'm having a hard time seeing why we need it.
Thank you. And as I end of our discussion, I appreciate it. What is the pleasure of this committee? Have a motion to pass. A second by Trey Kelly. Any more discussion for the committee? Those in favor of passing on this House bill, please answer by saying aye. Aye. Those in opposition? No. I believe the ayes have it. Thank you, Mr. Chairman. The bill moves on. I want to thank the audience for being very respectful. I hope you'll see that the discussion here is very sincere. And thank you, committee. We adjourn.